everyone's here. First, welcome to a room that is not as cold as the last one. Please, stop shivering whenever you get a chance. Welcome to our Marine Governance panel. Just quickly to introduce myself, my name is Mike Pappas. I am a newly minted member of the faculty here at the University of Maryland, and it's my pleasure to get to moderate this panel, which is just an absolutely fascinating subject, the marine environment being so much physically of our planet, being historically a commons, being so transboundary, transjurisdictional, so difficult to police. Marine governance provides this wealth of subject matter to talk about from the broadest range, right? What are our programs? How are we going to structure governing bodies? Who should be participants in those governing bodies? To the more particular facets of implementation, right? Site-specific questions, ecosystem-based management tailored to individual ecosystems, particular enforcement challenges tailored to specific regimes or specific areas. And today's panel is going to give us a taste of all of those different subjects. Since you didn't come here to listen to me, let me just jump in. But just to give you a sense of how we'll organize things, we'll hear from each of our panelists, and then after the presentations, we'll all sit up in the front and open to questions and discussions. And so, without further ado, let me introduce Professor Nilüfer Oral, who is a member of the law faculty at Istanbul Bilgi University and is the Deputy Director of the Marine Law and Policy Research Center. He's also the co-chair of the IUCN Specialist Group on Oceans, Coasts, and Coral Reefs, and the vice chair of the IUCN Academy of Environmental Law. Right? Have I said that right?
Yeah.
Okay. And so, please, Nilüfer, come.
Thank you.
And you should be all set up for your PowerPoint to, let me, there you go, you can just advance.
Thank you, Mike. Oh, from here. Yes, well, it's a great pleasure for me to be here in the University of Maryland Law School in Baltimore and be with colleagues, many of whom I know, the oceans people, yeah. And congratulations to you on your new position here. Very fortunate. Anyway, I'm going to talk today from kind of a broader view of the UNEP Regional Seas program. And I call it Bridging the Governance Gap, but to be honest, I have a long prelude to one specific point I want to make that will be on one slide. But nonetheless, give a little background before I get to that. I just made an outline of my presentation, looking at the background of the UNEP Regional Seas program, then where it is today, gaps, and then, well, I'm not sure it'll be clear-cut conclusions, but coming to some conclusion on this issue. I've been working specifically on two regional seas for some years now, Black Sea and the Mediterranean Sea. So part of my research led me to make some certain observations. Of course, as many of you know, and some of you may be just learning about oceans law, one important development that started really in the 70s is the whole idea of regionalism. And I think today we take it very much for granted that in shared marine space, you can call not necessarily always commons, but a shared space, that the coastal states should agree to cooperate in an area, frankly, where we have a long history sometimes of hostilities, actually, or disagreements. For example, the Mediterranean is an example where there are obviously maritime jurisdictional issues. But what makes the regional seas approach important is that we take those negative conflictual issues aside, and through regionalism, we've developed a system through cooperation, which is key in, hopefully, protecting the marine environment. That's the goal, at least. So this really started in the 70s. I think you may be familiar with Professor Louis Alexander, who was a great proponent of this, and really highlighting the need for states who share a common marine area to be able to cooperate and address common risk. For example, something quite common, I think, to many of these seas is the risk associated with the transport of hazardous, dangerous cargo, oil pollution, these types of things. And this regional approach really then became codified in the 1982 Law of the Sea Convention, and it's remarkable that we have an entire part 9, on semi-enclosed seas and enclosed seas, where the importance of cooperation among seas such as the Mediterranean, Baltic, Black Sea, many of these seas that are enclosed or semi-enclosed. But the coastal states actually are to cooperate in the management of the natural resources, living and non-living, actually. Then, for purposes of the UNEP Regional Seas Program, of course, the beginning was with the 1972 Stockholm Declaration. Today we're talking about 2012 in Rio, but 1972 was obviously a foundational meeting, and from there the UNEP regional unit was created, and through UNEP we got the Regional Seas Program. So many of you are already familiar, I'm sure, with the Law of the Sea Convention, Article 123, but what I'm highlighting here is that for states bordering an enclosed or semi-enclosed sea, the duty to cooperate, or it's an exhortative, but we didn't argue whether it's mandatory or not only is it directly, but it's through also an appropriate regional organization. And UNEP, the United Nations Environmental Program, is clearly an appropriate regional organization for effectuating that cooperation in the management of natural resources. So the first regional program was established in the Mediterranean in 1974. And it's, interestingly enough, the Mediterranean program probably stands out still as, at least when we look at the governance on paper. And really, I'm talking right now a lot of what's on paper, not necessarily implementation, but the most advanced of the regional seas programs. And there are right now 13 regional seas programs that are directly established by the UNEP Regional Seas Program, and 5 that are partners. That means that they were not directly established, but they are affiliated with the UNEP Regional Seas Program. And of the 13 that are directly established under UNEP, only 6 are UNEP administered, and the Mediterranean is one of them, and the others are not. Now, what's interesting about that, when we look at the Black Sea and the Mediterranean, the Black Sea is a non-UNEP administered sea, yet they're really linked. And what I'm going to get to eventually is that you're going to see there's a really different level of governance amongst these different regional seas. So the UNEP Regional Seas Program theoretically follows a common format. Theoretically, because I'm not sure that's really necessarily always the case. The first level is what you might call the science and policy level. What's important is they go in and do a scientific assessment, which is very important. Go in and identify the transboundary issues for the marine environment. A lot of it is pollution. It has been very much pollution focused, but now I think you're looking at changes because of climate change and other impacts on the marine environment. But traditionally, it's been looking at the pollution sources. This has been done by what's called a transboundary diagnostic analysis, and based on the results, a strategic action plan is developed and adopted by the state. So it's actually a commitment that the states make to follow the strategic action plan that has objectives and specific benchmarks that they're at least theoretically supposed to meet, not that they necessarily always do. Then following that, based on the science, the legal framework is established, and that's first through negotiating and adopting a framework convention. Now, these framework conventions differ. They're not necessarily all identical. Some are stronger, some are weaker. And of course, as you know, the whole environmental approach is you have the Framework Convention and implementing protocols on different activities and sectors. They have a secretariat, regional coordinating units. Some have subsidiary bodies. For example, the Mediterranean again has a regional activity center. And of course, finance is a big issue, and that's where UNEP is to come in and play an important role. All right, the current status, when I say current status, what is the UNEP Regional Seas program doing right now outside of what we see in these total of 18 Regional Seas programs? Well, they adopted between 2008 and 2012 what is the UNEP, and so this is the United Nations Environment Program in general, Global Strategic Directions. And the first one, which is important for the regional seas, is to enhance the sustainability and effectiveness of regional seas programs through increasing country ownership, incorporating regional seas conventions and protocols into national legislation. And it goes on. Problem, though, which I'm leading up to, is when we're talking about the protocols in particular, we'll see that they're not, all the regional seas programs are actually quite different. They don't have the same level. So when they're saying enhancing sustainability and effectiveness of the regional seas program, it doesn't really give an accurate reflection, actually, of what the real current status is of, at least when we look at the legal framework of these different regional seas programs, what it is. Also, the UNEP has right now adopted marine priorities, and the 6 cross-cutting priorities are there, but again, I'm focusing on environmental governance. So this is a priority, environmental governance. Of course, what do we mean exactly by that? That's another issue. And then in 2007, UNEP, they did apparently an in-house brainstorming workshop, and from this, they identified 7 priority areas in marine and coastal management. Many who are familiar with land-based pollution, loss of habitat, impact of climate change, very important, biodiversity, high seas, and islands. And based on this workshop, then UNEP, there's a lot of statements, identification of goals and whatever, and strategies. So this is based on those 7 priorities. Then UNEP adopted a medium-term strategy between 2010 and 2013. And on that, number 3 is probably one that comes closest to the governance issue. Now, I don't know really what we get out of all of this, because what is frequent is that these are all very general. It's like strengthening and doing this and incorporating this, but what we're lacking is actually details. And I realize it's important to have these frameworks, but when we come down to it, this is really what I wanted to get to. This is the current status of the regional seas programs. And I have to say, I mean, I may be missing 1 or 2 things, and if I am, someone can identify it. But when you look at the 13 regional seas programs and the different, there's a framework convention, these are the different protocols: dumping, land-based sources, biodiversity, emergency, offshore, IUCN, emerging, well, it's not really emerging, but for purposes of UNEP it is, climate change, compliance. We keep talking about compliance, but to me it's remarkable that really the Mediterranean is the first one to create a compliance mechanism. That was relatively recent, I think 2010. And even though compliance has been a big issue, it's not there. So when I look at, we go priority strategies, all this stuff, but I look at what's actually in place, it's, to me, something's wrong. There's something missing, because the UNEP Regional Seas program really, I think, should have been promoting, if you're going to have 13 regional seas, there should have been some standardization. There should be some level of commonality, but they're all so different. The Mediterranean Sea stands out as the one regional seas program that, again, as I said earlier, at least on paper, is more advanced. They have an IUCN protocol. They just finally, it took a while, but they finally put into effect the offshore protocol for offshore activities oil or gas, which in the Mediterranean these days is important. The Black Sea, for example, I know they have a lot of offshore activity going, and they don't have it. Even though that was a commitment they had made back in 1996, they still don't have it. So there is just what I call asymmetry. There's something missing. This is a common program, the Regional Seas program. I don't think there should be this level of difference. Okay, each regional sea may have its own particularity, they may be a little different, but I think you can agree that dumping is a common issue. It's a cross-cutting issue for all the regional seas, yet we see that not all of them have dumping protocols. Land-based sources of pollution. And when we talk about protocols also, there's first, second generation, whether they're reflecting the old standards or the newer standards. Though I said, okay, what are the gaps? These are the gaps, yeah. So I think more than conclusions, and I think that's probably well within my time.
Take as long as you need, or as short as you need.
It's not so much conclusions, but really asking questions. I think maybe having a discussion on that, because I look at that, go back to that, I look at that, and this is a program, since 1974 it's been in place, and it's an important program, there is no question about it. And UNEP and the Regional Seas programs have done great things, and a lot of it may not be reflected in the legal framework, because there's a lot of projects, on-the-ground projects. So then I ask the question, well, maybe too much stress on having legal instruments. Maybe we don't need to have these legal instruments. Maybe soft law is enough. But if that's the case, then why do we have then the Regional Seas program and then this legal framework of governance? So these are the questions. I think also looking to Rio, and it was wonderful today we had, I benefited greatly from people who've been to Rio and giving their feedback on that. But I know there was great expectations for the UNEP program to become an agency, and then it's good to hear from the UNEP representative that they're not disappointed, that UNEP will be strengthened, will get more money, which is important. But when I looked through that document, and really what I didn't see was any mention either for UNEP or in the oceans on regional seas. And I think that the Regional Seas program, it's a flagship program for UNEP, it's really an important, because the whole point of regionalism is that you take the global standards, obligations, you can bring it down to the regional level, and that is supposed to facilitate implementation at the national level as well, and through cooperation and coordination. So maybe there's not a governance gap. Maybe this is something that just appears that way. Again, these are questions. But I always say, is there a role for the IUCN? And I think this is something that the IUCN has been very active in the Mediterranean Sea. We've done a lot of good work, but maybe looking at the bigger picture of the Regional Seas program, maybe we need to address that and see if this is a significant gap and whether there's a way to actually bridge that gap. So, thank you very much.
Thank you very much for that. Next, we'll get to hear from Elizabeth A. Kirk, who is a senior lecturer at the University of Dundee School of Law. She joined the School of Law in Dundee in 1995, was promoted to senior lecturer in 2003, and prior to that qualified as a solicitor in Scotland and worked as a research associate at the University of British Columbia. The main focus of Elizabeth's research is adaptability within legal regimes. In particular, the ability of regimes to respond to changing circumstances, scientific understanding, that is changing scientific understanding, or changing actors. This has led her to publish on issues such as the relationship between law and science, compliance with and implementation of international environmental law, public participation, and regulatory approaches to environmental protection. Elizabeth's research has also led her to work with intergovernmental, non-governmental and governmental bodies. And she is currently one of 2 co-editors for the IUCN Academy of Environmental Law's e-journal, and is writing a book on governance in the marine Arctic.
Okay, well, thank you, Mike, for that very kind introduction. Actually, as I've got your attention, in my role as the one of the co-editors for the e-journal, I am soliciting contributions. So I'm going to talk about this hopefully later in the conference, but if anybody is interested in finding out more about the e-journal, please do speak to me at some point, because we are very keen to hear from new writers. Okay, so I'm talking about, I think, some of the same themes that Nilufer has been talking about, but from quite a different sort of perspective. I'm interested in talking about how regimes respond to perhaps threats or to changes in activities. And my starting point in my research was to look to see whether what happened was that you would have a change that would automatically prompt a development in the law, or whether changes were dependent on the norms that existed within a particular regime. And what I found, I think, is something a little bit different. So, I mean, I'm sure if we think about examples, we can all think of things where there's been a major event that's led to the development of the law. But I think those of us who've been working, particularly in environmental law for a long time, can also think of many instances where there's been some form of development which hasn't led to a development in the law, or in which the law has changed, but not in the way that we might have anticipated. So if I can give you just one fairly recent example, the issue of carbon dioxide capture and storage has been examined by the IPCC. They produced a report. They pointed out that the technology is quite new. It hasn't really been tested. Obviously, it's a very risky activity to try and take gas and sequester it in a rock formation. And so basically the recommendations of the committee was that before any authorisations be given, that we ought to ensure that we have effective monitoring in place, that we ought to ensure we have effective regulation in place. So they really recommended a precautionary approach. So when that was discussed then by the parties to the London Dumping Protocol, whether the issue of sequestration was adopted, or discussed, I should say, I perhaps naively assumed that, given that the protocol has provides that the parties are to take a precautionary approach, that they would, at the very least, put in place a regulatory framework before authorising sequestration. But they didn't. They authorised sequestration and said, well, we'll do something about the framework when we can, or as soon as we can, at least. So, why then? Why then do we have these changes? Well, in my research, what I've found is that it comes down largely to what we call politics. So, in a slightly more complex fashion, I've drawn on Paul Sabatier and Hans Jenkins Smith's framework of the Advocacy Coalition. Basically, their framework, or their theory, argues that policy making takes place within a subsystem. So for international law, we're looking at regimes, and in those subsystems you have various advocacy coalitions. We have groups of actors coming together to try and argue to get the dominant position, to have the policies developed in line with their interests or beliefs. So we might assume in international law then that our actors are going to be states, largely. But in the work that I've been doing, it's not quite, or what I found is that the picture's not quite as simple as that. Instead, what we find, or what I found, is something that I've termed advocacy coalitions working within multidimensional policy networks. So the coalitions consist of both states and non-state actors, largely civil society actors. And they interact in a variety of ways, and what I've called multidimensional policy networks has some similarities with the idea of transnational network governance, which you might be more familiar with, but where transnational network governance focuses on the relations between governance agencies and each other, or governance agencies and regimes, and the ways in which those agencies cooperate. I've taken a slightly broader picture. So we're looking at the interaction between states and non-state actors, and the ways in which they, in fact, forum shop. So they're not just focusing on a particular regime that you might anticipate they would focus on, they are looking more broadly and acting more broadly. So what I want to do next is give you a couple of examples. And I've picked examples that I hope are fairly well known so that I don't really have to say anything much about background. So my first example is the adoption of the whaling moratorium in the International Whaling Commission, I should say. Now, when the idea of a moratorium was first mooted in about the 1970s, it was mooted in a regime which was very much focused on regulation of whaling rather than conservation. And when it was first mooted, you had the scientific community responding and saying, well, it's an interesting idea, but we need to do more research. So, in response to that, the IWC said, okay, let's authorise more research. And you then had an advocacy coalition that was interested in conservation beginning to work at national and international levels. So you had lobbying by NGOs at national levels and at international meetings. You also had lobbying by states at international meetings and with other states. This had two results. First of all, it persuaded, the lobbying activities were sufficient to persuade some states to move from being whaling states to being conservation-minded states. And it also persuaded some states that weren't already party to the IWC to join within one of the coalitions. And there was also the counter-coalition arguing for the continuation of whaling. So you had more states joining. The effect was then that within the IWC, the dominant advocacy coalition changed because you had sheer dint of numbers, you had more states party to the conservation coalition than party to the whaling coalition. At the same time, and to my mind somewhat more interestingly, you had these actors effectively forum shopping and lobbying in other events or in other regimes. And the result was then, the result of lobbying by both NGOs and states was you had the adoption in Stockholm of Recommendation 33, recommending that a moratorium be adopted, and you had the adoption of various provisions within CITES that were designed to support any conservation measures adopted by the IWC. So what I'd suggest is that what this did was it changed the context of decision making within the IWC. It was no longer the case that decisions about whether there should be conservation measures or regulatory measures were adopted or were going to be taken just within the context of the Convention for the Regulation of Whaling. It was being taken in this wider normative context, which now supported conservation far more. And so that made it much easier to adopt the whaling moratorium. I have another slide on the return to whaling, but I think in the interest of time I'm going to have to miss that. All I'm going to say very briefly is that while the whaling states still continue to try and change the position within the IWC and to have a resumption of legally authorised whaling that's not scientific whaling or subject to one of the other exceptions, I don't think it's going to be successful, and the reason is that I think there's this new actor, well, relatively new actor, which is the whale watching community. It's become, as you can see, quite an important source of revenues for different countries. It's an important activity within many, the vast majority of the member states within the IWC. I think it's about 84% of them have whale watching within their activities, within their waters. And it's even a relatively important activity in some of the whaling countries like Iceland and Japan, where they generate more income from whale watching than they do from any commercial whaling, any commercial use of whales. Okay, so I want to give you another example, just so that it doesn't look like I've cherry-picked the best example. I'll talk a little bit about the introduction of or the reintroduction of the prohibition on disposal of offshore installations that followed the proposed disposal of the Brent Spar installation, which was initially permitted by the UK. Now this is again a very simplified account of it. When the UK initially authorised disposal of the Brent Spar at sea, it did so under the Oslo Convention. It followed the procedures that were set out in the Oslo Convention. There is no question but that it complied in its activities with international law. There's also no question, but at the time, the proposed disposal of the Brent Spar at sea met with the approval of the scientific community. The scientific community said that was going to be the least harmful way of disposing of that particular offshore installation. Despite that, there followed extensive lobbying, again by Greenpeace, and also some action by some other states, and that led to the adoption, first of all, of Oslo Commission Decision 95-1, which prohibited the disposal of offshore installations. Now, immediately following the adoption of that decision, the UK and Norway issued reservations, and why that's significant is that they are the two states with the vast majority of offshore installations that were going to be covered by the decision. So their reservations had the potential to make the decision completely ineffective. What happened next? The next locus for activities was the meeting of the parties to the London Dumping Convention. They adopted the 1996 protocol, which again permitted disposal of offshore installations. It provided the parties had to take a precautionary approach to disposal, but provided that precautionary approach was followed, then disposal was perfectly legitimate. Now that might have been the end of the story, but of course the UK government had faced and continued to face a lot of criticism within the media, criticism again from NGOs, and you still had the other parties to the Oslo Commission, many of the other parties to the Oslo Commission, who were keen to see an effective measure adopted within that commission. So what happened next was you had a statement by the UK's then Secretary of State for the Environment saying the UK was going to take the lead, it's going to adopt some very strong provisions that would again prohibit effectively any disposal at sea, and it was going to take the lead in the international community. And finally then you had OSPAR Decision 98-3 adopted, which again prohibited the disposal of offshore installations at sea. With some exceptions, it allows concrete footings to be left at sea, and it allows for disposal in emergency situations. Okay, so what can we learn from these? Well, this is where I think I'm somewhat in agreement with what Nilufer was saying earlier, but I got perhaps some different points to make. I think the first point that my research hopefully shows, and I'm hoping to publish this work in a longer paper, hopefully in the Yearbook of International Environmental Law, and I'm also in that paper looking at the question of fisheries and how these issues have been explored in some of the regional fisheries regimes. But anyway, what I hope that I've demonstrated is that change doesn't come about simply because, or change within the legal environment doesn't come about simply because of a change within the environment more broadly, or that changes within economics or scientific understanding. Nor does it depend, as I thought it might, upon the particular principles that are adopted within a regime. So the example of CO2 sequestration clearly shows that the particular principles, there you have a precautionary principle operating, didn't necessarily lead to the response that at least science would have expected, pointed us to. What it does depend on very much is on whether the change that we might expect within the legal regime fits with the interests or beliefs of the dominant advocacy coalition. And that advocacy coalition consists of more than just the state, it consists also of other interested actors. The examples I've shown also perhaps point to the fact that the use of multidimensional policy networks might provide a way around any blockages within the system. But it's not guaranteed. It's very much an ad hoc system. It depends on the goodwill of different actors, and it depends on them having a particular interest. So how can we address that then? Well, one solution is to have more principles, perhaps to have a global regime that then points to the principles that should be adopted in particular regional bodies. But that's not always going to work. Something else might be required. So what I would suggest is that we start to do in marine governance what we're seeing happening elsewhere. We start to engage more fully with a range of actors. And this needs to be done in a couple of ways. In looking at regional fisheries regimes, what you see is that there are in fact sometimes blockages to participation. So you have to show for a state or for a civil society actor to become engaged in the regime in any way, they have to show an interest in the fisheries. So first of all, those sorts of blockages maybe have to be reconsidered and perhaps removed. But secondly, I think within marine governance, if we really want to have a regime or regimes that reflect the interests of society and of the environment, and I think those two interests are not really separate, then we need to start broadening out and trying to take a more proactive approach to participation, the sort of approach that is being taken at the national level, and actually starting to invite a range of actors to participate. When you start looking at the detail of who attends the different meetings, you see that it's industry groups, environmental groups. Maybe it's time to also start inviting human rights groups, consumer groups, and start broadening it out more fully. And perhaps even taking a more proactive approach to inviting different types of environmental groups. So that's the suggestion I'm going to leave you with. I think there are many potential pitfalls with that, but I'm going to leave it to you to point them out, if you like. Thank you.
Next, we'll hear from Mr. Ninye Liu, who is currently finalizing his PhD research at the Department of Public International Law at Ghent University in Belgium. Before beginning in Belgium, Ninye obtained his Bachelor's of Law and Master's of International Law from the law school at Wuhan University in China. He has several publications in international and national journals, including Ocean Development and International Law in the Journal of Maritime Law and Commerce. He's also the assistant editor of the Asia Pacific Journal of Environmental Law, published by Sydney Law School. He's given lectures and presented his research all throughout the world, and he was awarded the Chinese Government Award for Outstanding PhD Students Abroad by the China Scholarship Council in 2010. He also received a competitive grant from the National Fund for Scientific Research in Belgium in 2011 and conducted a 6-month field research trial along China's coast. And we will be hearing about that now. Thank you.
Thank you for your kind introduction.
Thank you for presenting. There we go, you're all set.
Hello, everybody. This notes, I think. Yeah. So it is always a great pleasure to present present my research as a PhD student and junior researcher in such a prestigious conference. So what I'm going to tell you today is about implementation story in China. So as environmental lawyers, I think most of you realize that the implementation is a kind of key issue for the effectiveness and the success of legislations. So, although I'm going to tell you a story about China, which I did conduct some research last year, but it might be interesting for people from the rest of the world to learn something from this. So my research is about law, my topic is about law in the book and law in practice, about criminal liability over vessels source marine pollution in China. So my presentation consists of 4 parts. First is kind of brief introduction about where is research from, why I'm inspired of doing this. And second is Chinese law in the book about criminal liability. And third is Chinese law in practice. And finally is the way forward. So, so first I try to tell you briefly why this criminal liability over vessel source pollution is kind of issue that I'm going to talk. This is actually inspired from the European practice. Like in 1999 and also in 2002, there are two serious oil tanker spill disasters happened in the European waters. First is Erika and then Prestige. So the European Commission has declared that the normal framework for international action on maritime safety under the auspices of International Maritime Organization falls short of what is needed to tackle the causes of such disasters effectively. So the EU adopted the Directive 2005/35 and later the Directive 2009/123, which specifically imposing criminal liability over vessel source pollution. So this is kind of a controversial issue, but I'm not going to talk more. But then one interesting point is, after EU adopted this directive, the international shipping community, especially the Intertanko and Intercargo, they sued the European Commission in European Court of Justice to challenge this directive because they think that this directive is in violation of international law. And also in Asia, we have similar stories nowadays. Like in 2007, oil tanker spill disasters called Hebei Spirit. Hebei Spirit is a vessel registered in Hong Kong, but actually owned by a Chinese company. Leaked oil in the South Korea waters, which caused the most serious oil spill disasters in the South Korea's history. So the Indian captain of this Hebei Spirit tanker was actually arrested and sentenced to be imprisoned for 18 months. In South Korea. So this actually raised the riots from the international shipping community, especially international seafarers, because they feel that this is, almost unacceptable to be imposed criminal liability in such a dangerous career. But what's the situation in China? This is why I'm really interested in. And first, I would like to show you a picture. This is a picture I really like. I think little of you saw it last year. This is a picture made by the China State Oceanic Administration, which shows clearly about the marine pollution issue now in China. You can see that this is China's coastline. It's about 18,000 kilometers. And then this black areas is the area which is seriously polluted. But the difference is that last year, for half years, I traveled along this coastline from the north, Dalian, to the south, to Haikou. So I traveled for half a year, conducted interviews, and also do some observations with the local practitioners from the government shipping industry. So I try to identify this is a broader topic than what I'm going to talk today. It's a broad topic about what is law in the book and what is actually really implemented. So this is some statistics that in 2010, 48,000 kilometers of there are 48,000 kilometers of polluted sea areas within China's jurisdiction. And also vessel source pollution is kind of really a serious threat for the Chinese marine environment, because China now is the world's second largest oil importers. Like in 2010, China imported 239.31 million tons of crude oil, and 95% was carried by maritime transport. So this created a very high risk of marine pollution from the vessels. So oil spills of more than 10,000 tons. Why I mentioned 10,000 tons is because both Erika and Prestige, these two serious oil tanker spill disasters happened in Europe, leaked more than 10,000 tons oils. Have yet to happen. However, between 1973 and 2006, a total of 2,635 oil spill accidents have occurred, and a total of 37,000 tons of oil has leaked into sea areas. So, China has also adopted a kind of legal framework to deal with the vessel source pollution issues. China ratified the Law of Sea Convention, and China is also a member of the MAPO Convention, which is the International Convention on the Prevention of Vessel Source Pollution, adopted by the International Maritime Organization. And China has adopted its own domestic law, the Marine Environment Protection Law, first adopted in 1982 and amended in 1999, and then Maritime Transport Safety Law. And most recently, in 2009, there is a regulation adopted on the prevention and control of marine pollution from vessels. And the major institutions that involved with this marine pollution issue is mainly the Maritime Safety Administration and also State Oceanic Administration, and for some issues, especially the pollution from the fishing vessels, is State Fisheries Agency. So there is a whole chapter of Chinese marine environmental law deal with the liability issues. So liability issues of marine pollution. So, but most of the sanctions that in the Chapter 9 that can be used for the prevention of vessel pollution are administrative measures. From an environmental point of view, criminal liability is necessary, since this is my own opinion, and since like the maximum fine for the marine pollution in sea areas under China's jurisdiction is only around 25,000 euro. This is the highest maximum fine that you can impose, you can be imposed on any marine pollution accidents. This is, I mean, not enough, of course. But from a shipping perspective, there might be different opinions. China is now also the second largest seafarer supplier in the world. So you can see here that actually there is a balance. We are the second largest oil importers. We have a very big shipping industry. But the marine environment is also a key issue to China, because you have such a long coastline, and most of China's advanced areas are along the coastline. So how can you balance this interest? So there does have one article in the China's marine environment protection law that links to the criminal law. It says, in case of significant pollution of the marine environment resulting in major damage, criminal liability shall be imposed according to applicable law. So this is actually copied from the Law of Sea Convention, because here, if you are familiar with Law of Sea Convention, you can see the significant pollution and also the major damage. This is the same words used in the Law of Sea Convention. So, but these two terms are quite vague. They have not been explained by Law of Sea Convention. And also, there is no explanation, further interpretation about these two terms. What is significant pollution and what is major damage? So this article linked to the criminal law in the marine environment protection law was added in accordance with the Chapter 6, Section 6 on the crimes of impairing the protection of the environment and resources in the criminal law of Chinese criminal law. And in the criminal law, there is no specific offense of polluting the sea. But it seems that Article 338 is the most suitable likely offense that fits with the marine environment protection. So basically, the idea is, the article says, in violation of the regulations of state, discharge, dumps, treat radioactive waste containing pathogens of infectious disease, toxic substances, or other hazardous waste, thus causing a major environmental pollution, then you will face certain criminal sanctions, such as imprisonment. But this actually is another development in Chinese law, because this article was amended last year. So you can see that there is actually a difference. So the 1999 Chinese Marine Environment Protection Law links to the previous Article 338, which mentions specifically great loss of public or private property, bodily injury or death of another person. This is the cause of imposing criminal law. But this was not mentioned in the new Article 338. So serious consequences of heavy losses of public or private property of human casualties is no longer a condition for the application of criminal sanctions under Chinese criminal law. So, but what's the law in practice? Until now, there is no case in any Chinese court that imposed the criminal liability over vessel pollution. Probably you know that China is not a case law country, so you can't really access to the court report. But I talked to so many people in different courts, and then I find out actually there is no such kind of case, although there is an article there. So what's the reason? I was really wondering what's the reason for this. So I think the first one is, does the Maritime Safety Administration, and this is the government administration which is dealing with vessel pollution, they really want to impose criminal liability, criminal sanction over vessel pollution or not? Because why? First, the fine. I mean, to impose administrative fine is easier. You just catch the boat and then impose a fine and let them go. This is quite easy, and then you can make some money. And the second possible reason is the shipping industry contributes greatly to the economy, and also China is now is desperately developing its economy and to create more jobs, and seafarers is a nice a nice industry that can provide jobs, I think. So China is also the second largest seafarer suppliers in the world. Protection of its seafarers' interests is the priority for the Chinese government, because also it's like, if China impose, there is one concern is that something comes wrong, goes wrong. If you impose criminal liability over foreign seafarers in the sea areas under China's jurisdiction, then other countries might also impose criminal liability over Chinese seafarers. So then this is kind of concern. And second is the technical. I think this is a technical reason why there is no case. Real case in practice. So the problem exists of the link between the marine environment protection law and the criminal law. So Article 91, Article 91 of the 3rd of 1999 Marine Environment Protection Law describes that significant pollution and major damage can result in criminal liability. But this is very subjective and has not been clarified. So the court does not know how to. I mean, they can interpret, of course, but they don't know. Basically, they don't know how to easily impose criminal liability over any vessel pollution accident. And also the provisions not only requires accident which was caused in violation of the Marine Environment Protection Law, but also that it caused a major damage. In this case, not only the illegality, but also the required result, means that the law would only intervene at the very last stage. And the burden of proof for the public prosecutor would be also very onerous. You need to prove the major damage, that then you can impose this criminal liability. This is a little bit difficult for them, I think. And also, who can deal with this issue? Which department can sue the captain or ship owners to the court? Is it Maritime Safety Administration? Which level of Maritime Administration? Because they have 4 levels of offices within the system. Or work together with people's procurators, the so-called 检察院, Chinese Attorney General, in brief interpretation. So, and which court can handle this case? There are special maritime courts besides local courts in the important coastal cities along China's coastline, in Tianjin, Dalian, Shanghai, all these important ports. China has established its own maritime court. But criminal cases on vessel pollution is not within. Currently, it's not within maritime court's jurisdiction, but it seems that it's reasonable that specialized maritime courts may be more capable than other local courts. But now I come to my conclusions. So it's kind of also way forward how we can improve the situation. The first is that there is a gap between the law in the book and law in practice to impose criminal liability, criminal sanction over vessel pollution in China. The Chinese government has to make a balance. I mean, they have to decide make a balance between its shipping interest and coastal interest. And third one is the Marine Environment Protection Law needs to be revised. It is not incompatible with the current criminal law. It is also not clear about imposing criminal liability over vessel pollution. And finally, it's like there is some possible highlights of revisions. What can be revised? First is more details about significant pollution and major damage. And this is something a state can do because it's under the Law of Sea Convention, and you can interpret this Law of Sea Convention terms in the Law of Sea Convention. And second is clear links in the Marine Environment Protection Law to the criminal law. And third one is the change of proof, of burden of proof. And finally is identify competent department courts. So thank you so much for your attention, and I hope to discuss with you in the coming term.
And then finally, now we get to hear from Dr. Yu Ming, who is a faculty member of the School of Law and Political Science at the Ocean University of China. Her research area is marine environmental protection law and water pollution law. She's published several articles in the key domestic academic journals and codified a book on the regional laws and conventions related to marine environmental protection. She is the editor of the Chinese Environmental and Natural Resources Law Review. Dr. Yu Ming also directs the international academic cooperation and exchange in her law school and runs an LLM program in environmental and natural resources law for international students. Before joining the faculty, she worked as an associate expert in the UNDP GEF Yellow Sea Large Marine Ecosystem Project Management Office to help develop the regional action plan.
Thanks, Chairman. Good morning, everyone. My name is Yu Ming. I'm from School of Law and Political Science, Ocean University of China. Today, I'm going to talk about strengthening regional ocean governance to protect the marine environment. I'm going to talk about a case that I've been working together with them for 5 years about the Yellow Sea Large Marine Ecosystem Project. I'll mainly cover three parts in my presentation. One is the introduction of the IUCN project and its achievements. The second is the regional ocean governance framework, the structure that we've been using in the project. And third is what are the weak points of this regional ocean governance structure. Now first I start with the first part, introduction of the IUCN project. The IUCN project is a regional sea project that funded by UNDP, GEF, and China and the Republic of Korea. This is the geographical boundary of the Yellow Sea Large Marine Ecosystem. I think from this map you can see it more clearly. It's within the red lines and the coastal line of China and the Republic of Korea and the DPRK, so 3 coastal countries. The major Yellow Sea was regarded as one of the 64 large marine ecosystems in the world, but it is a very productive sea area. It supports a large population of fish, birds, marine mammals, and also a huge population, a huge human population, because China and the ROK and the DPRK are the coastal countries. The major environmental problems listed by the scientists are marine pollution, which may cause eutrophication and oil pollution, and also the decreased fish stocks, and also many other problems. So the Yellow Sea project, UNDP, GEF, China, and ROK established this project. The aim of it is to help the coastal countries to improve their political and legal system on ocean governance to protect the marine environment. And also they try to settle the environmental problems with priorities. After 8 years of implementation, the first phase has been finished, and now three coastal countries are working together to apply for the second phase of the IUCN project. And so I think it's very helpful at this time to think about what we have gained from the first phase and what we're going to improve during our second phase, if we are lucky to have the second phase for the funding from UNDP and GEF. So I'm going to quickly review the major achievements that have been received during the 8 years of implementation. The first is we have a practical strategic action program or strategic action plan. It develops 11 regional targets and also develop actions, including 2 levels: technical actions, governance actions, and legal and institutional actions. These strategic action plan will serve as guidelines for the project from 2010 to 2020. This is what the first achievement. The second is the joint data research activity. Yellow Sea Large Marine Ecosystem Project has launched 2 joint crews to get the first-hand scientific data from the surface water of the Yellow Sea. This is through 2.5 years of hard negotiation. This is very important for the whole region, for the regional governance, because the environmental problems identified in the TDA, the environmental governance action that are gonna take in the SAP, all based on the results from this joint data research. And also another important reason that why joint data research is very important, because it is actually a political sign that telling the coastal countries that we need to cooperate together, and that we need to carry on this cooperative spirit. The third one is we are successfully pulled DPRK into the regional project, because you may notice that during the first phase, DPRK is not a member of our project. So in the second phase, right now 3 countries are working together to apply for the project, and the DPRK actually is very active in joining this activity. Of course, by doing this, we got a chance. We ensure that the geographical integrity of the Yellow Sea large marine ecosystem, and also it provides a platform for scientists to change data, and also it stimulates some experience on how we can get some countries with different political ideology and political system to work together to protect the common environment of our human being. Because the political system in the Yellow Sea large marine ecosystem is very complicated, with China, a communist country, with DPRK, more communist than China, and then with ROK, and these 2 countries, actually DPRK and ROK, are fighting together. It prevents the participants from, DPRK prevents its participants to go into ROK to join the UN meeting. So most of the meeting has to be held in China. It did contribute a lot to the economy of Chinese economy, and also the demonstration activities. Right now, 8 demonstration activities are carried out in China, and some are already received very good results. These are the major achievements. Now I'm going to talk about the structure of regional ocean governance in the YSME project. First, I would think that YSME project has been achieved a lot because they have a special structure, ROG structure. The first is they have an effective regional coordination framework. This is a framework. And they have the top level is a project steering committee, including UN, UNOP, GEF, and China and Korea. So it forms a communication channel for UN and participating countries. They are working together to decide what they're going to do in this regional project. And then they have if you see from the straight road, then they have regional scientific and the technical panel. They have regional working groups. So this regional scientific and the technical panel, including the national project coordinators from both coastal countries, including the the one from project steering committee, and also including the chairperson of regional working group. So it forms a coordination platform for participating countries and the regional groups. So including all the regional experts, they can talk together on the regional problems and policies. And also PMO serves as a secretary of the project, helping to facilitate the negotiation between the PSC, between regional groups, regional scientific and technical panels, and also the participating countries. It did a very good job in regional coordination, and the framework actually also includes national coordination framework, which I think is not a very good job. I'm going to talk about it later. Is the interministerial coordination committee. This didn't work quite well. This is one factor. The other is the regional ocean governance ensure a wide participation of stakeholders. In order to fulfill this task, the YSME mainly going by two processes. One I call top-down process. The other is bottom-up process. The top-down process, I know many scholars arguing that the ROG, Regional Ocean Governance, actually is a bottom-up process, trying to attract different stakeholders to join in the process of governance. But I do think in a country like China, especially China and DPRK, the top-down process is more important and more effective, because according to our constitution, the power to manage the country comes from the people, and the National People's Congress, or you can say parliamentary in your system, or legislator in a legal system, in a legal point of view, is the representative of people. And the NPC, or the parliamentary, actually are authorized the power to manage the country into the government. So we have very strong government. We have very strong parliamentary system. So by educating the parliamentarians, by educating the legislators, it's more effective to get the regional ocean governance done in the country, because the government controls more resources than the common people in China and the DPRK. I don't quite understand the situation in Korea, but I think in China it's like this. So parliamentary meetings have been organized in the project, which is the first one of this kind in the regional project, and also local government training are organized. And then the bottom-up process is also very helpful, because it helps, like the youth program, the intern program, small grant program, they all target at different objectives. And they do help to raise the public awareness and the public participation spirit in the country like China, where it lacks the basic public participation. So by doing this, it ensures a wide participation of stakeholders. And the third is an ecosystem-based approach. The ecosystem-based approach is a science-driven approach, I should say, that by carrying out TDA, by carrying out the joint data research, we do most of our decisions based on the science. And also we use the concept of ecosystem carrying capacity during the design of our targets and actions. We have 11 targets in our SAP, like reduction in fishing intensity, rebuilding depleted fish stocks, improvement in mariculture techniques. These are targets they have maybe mainly targeting at improving one services of ecosystem carrying capacity, but they do influence other regulating services, cultural services, and supporting services, all influence other services. So in order to in order to improve the ECC in the ecosystem, we can do it so by fulfill those 11 targets. So this is why the targets come from, and also we design this design our actions using the concept of ECC. I give you a very simple example. Like this is our first target. Is we decide to reduce 25 to 30% in our fishing effort, and we will rebuild fish stocks. We will improve sustainable mariculture techniques to reduce environmental stress. Why we design the actions like this? Okay, because this is the fishing data that the scientists get. So you can see from 1952 to 2003, there is a sharp decrease in the fishing in the fishing effort, and also some very not very economic species have been taken the most are the most fish that we can get from the sea. So we decide to control the fishing effort. This shows that if this is the total boat number, and that is the China total captures. So if we decrease this total capture by 1/3, China will have a serious lack of fish protein. What can we do? So we will meet this gap by agriculture. But look at this gap. This is a global agriculture, and that's what China did, and that's what Korea did. So China's every year the tonnage of agriculture already reached to 40 million. If without a very good regulation, it will have severe impact on the ocean. So our idea would be, the problem is overfishing. We're going to reduce fishing effort. So reducing fishing effort will reduce protein from seafood. We will use mariculture to meet the gaps. But mariculture will cause a serious environmental impact. So scientists come out with an idea called integrated multi-trophic agriculture. Well, the scientists offer me from the Yellow Sea Fishery Organization gave me this chart. I don't quite understand what was inside, but I was told that the benefits of this IMTA is the waste of one species is the food of another, so it's recycle. Yeah, that's why that's how we design our actions, and then by the first project in the Yellow Sea region to promote regional ocean governance, I do think that YSME has reached a very good result, but there are still weak points in this ROGE structures. The first is there is an ineffective national coordination mechanism. The ineffective national coordination mechanism, both in the Chinese government and the Korean government, actually prevent the project from reaching a better result. Because, like, take China as an example. China has five administrative organizations that have their duty in the sea. State Oceanic Administration, Ministry of Agriculture, Ministry of Transportation, Ministry of Environment, and the Navy. Within these 5 organizations, State Oceanic Administration is a national project coordinator, but it is one level lower than all the other 4. So it is coordinating ability is relatively weak. It cannot really did a good job. It didn't do a very good job to try to coordinate between all these ministry level departments and to get we have strategic action plan, but unfortunately we won't reach for the next step, which means we won't reach to the next step to build a convention, because it's very difficult to get as State Oceanic Administration as a national project coordinator cannot get the SAP turn into national laws, because it cannot pass through all these 4 ministries. So I think if we have the second phase, if we are aiming at a convention, because if we can't reach any convention in the Yellow Sea, it's impossible to reach in other sea areas, because other sea areas, the political issues are more complicated than the Yellow Sea area. So if we're aiming at some convention-based regional ocean governance, then we need to have effective international, inter-ministry coordination committee should really function, otherwise we cannot reach. The second one is lack of total planning of the region. YSME did some good job, but it did for some transboundary issues. YSME lacked it's not that effective, because like fishery, there's depleted of some kind of fishery resources, but some fish migrate from the East China Sea to the Yellow Sea. So Yellow Sea large marine ecosystem only regulates this small area. In order to touch this transboundary issue, we need to build cooperation between the East China Sea and Yellow Sea. So we need to, when we design the program, we need to have a more broader picture. We need to have a total planning of the region. This is the second big point. The third is we lack of scientific study of the ECC method. We are only using the concept, but we don't have the mass models. So scientists are working towards it. But since ECC is not stable there, it moves. We need more supports from the scientific area on how we effectively modify our actions. These are the 3 weak points of our GI in the YSME project. And I'd like to welcome your questions and suggestions. Thank you.
So one of the major themes you often encounter in marine governance and environmental law in general is limited resource and trade-offs that have to be made. And a trade-off we currently face is saving time here for questions or getting you to lunch on time. And so I'd like to offer on behalf of our panelists that they would love to receive your questions maybe over lunch so that all of you can be well fortified both mentally and physically. So rather than do what we planned, sit up here and have some question and discussion now, maybe we retire to lunch at this point, have some question and discussion over lunch. But once again, thank you to all of our panelists for excellent presentations.